We have all seen the viral videos online. A citizen is standing on a sidewalk, holding up a smartphone, and recording a police interaction. Within minutes, an aggressive officer walks over, blocks the lens, and demands that they stop filming, claiming it is illegal, a safety hazard, or a violation of privacy. As an attorney who has watched these constitutional battles play out in courts for over 30 years, I can tell you that the police make up fake laws on the spot more often than you think. But here is the reality. You have an absolute, clearly defined First Amendment right to film police officers performing their duties in public spaces. This is not a vague or gray area of the law, and federal circuit courts across the United States have ruled on this time and time again, establishing a binding legal precedent that protects you. When an officer approaches you and says you need permission to film, or that you are violating their personal privacy rights, they are flat out wrong under the United States Constitution. Public servants operating in a public space funded by taxpayer dollars have absolutely zero expectation of privacy under the law while executing their official duties. If an officer threatens you with arrest, intimidation, or retaliation simply for holding a camera, they are committing a serious constitutional violation that strips away their qualified immunity. However, knowing your rights is only half the battle. Knowing how to assert them without getting yourself physically harmed or arrested is what actually protects your freedom in the moment. The second an officer breaks away from what they are doing to confront you about your camera, you need to remain completely calm. Keep your hands entirely visible and say these exact words. "Officer, I am recording from a public space, and I am not interfering with your duties." That specific word, interference, is the golden legal line that determines whether you walk away free or leave in handcuffs. While the First Amendment gives you the robust right to gather information and film, it does not give you the right to obstruct an active investigation, cross an established crime scene tape, or compromise officer safety. If you are standing 2 feet away from a traffic stop, yelling at the officer, or blocking their physical path, you are no longer just a bystander recording. You are legally obstructing a peace officer, and you will get arrested. To maintain your absolute legal protection, you must stand at a reasonable distance, usually around 10 to 15 feet back, and remain silent while recording. If the officer orders you to back up to create space, do not argue or debate the order. Step back immediately, maintain your distance, keep the camera rolling the entire time, and calmly ask, "Am I free to go, or am I being detained?" If the officer says you are not being detained, you have the legal right to walk away or continue filming from that safe distance. If they say you are being detained, they must have reasonable, articulable suspicion that you have committed, are committing, or are about to commit a crime, and filming them does not count as a crime. By using these precise legal terms, you instantly signal to the officer that you know the law better than they do, and you set a massive legal trap for them if they choose to violate your civil rights anyway. Now let us address a critical twist that catches thousands of people off guard: the distinction between public property and private property. Your First Amendment right to film applies to public spaces like sidewalks, streets, parks, and plazas. However, if an incident spills over into a private business, a shopping mall, or a residential driveway, the rules of engagement completely change. On private property, the owner or manager has the legal authority to set a zero recording policy, and refusing to stop or leave means you can be lawfully arrested for criminal trespass. Furthermore, you need to know exactly what happens if an officer tries to seize your device. Under the Supreme Court ruling in Riley v. California, the police cannot search the digital contents of your phone without a valid warrant, even if you are under lawful arrest. If an officer commands you to unlock your phone or demands to see the footage you just recorded, you must state clearly and firmly, "I do not consent to a search of my property, and I do not consent to unlocking my device." If an officer goes a step further and physically takes your phone and deletes your video, they have not only violated the Fourth Amendment, but they have also committed evidence tampering and spoliation, which is a major felony offense in many jurisdictions. To protect your footage from ever being lost or destroyed on the scene, you should always stream your video live or utilize cloud syncing apps that instantly back up your data to an off-site server the moment it records. Securing your footage is your shield, your leverage, and your ultimate protection against institutional overreach. If you want to stay deeply informed on how to navigate these high-stakes encounters and protect your constitutional liberties with real legal facts, make sure to hit that subscribe button right now. Leave a comment below letting me know if you have ever been threatened by code enforcement or police for recording in public, and tell me exactly which legal scenario or police encounter you want me to break down in the next video.